Accommodate for Employers. I'm Cynthia Calvert. Before we get started today, I'd like to thank the Kellogg Foundation and the Novo Foundation for providing funding for today's program. Today we'll be discussing pregnancy accommodation, focusing on recent changes in the law and discussing not only what you have to do, but what is best to do to accommodate pregnant employees in the workplace. After we discuss the recent changes in the Americans with Disabilities Act and the new state and local laws that require accommodation, we'll look at accommodation under the Pregnancy Discrimination Act and the Family and Medical Leave Act, and then we'll turn our attention to how you apply all of these laws on a day-to-day basis in the workplace to keep things running smoothly and to avoid lawsuits. You can find handouts for today's program on the page where you registered, and the link, if you don't have it, is at the bottom of the screen. Also, if you visit this link in the next day or two, the slides from today's presentation will be posted there, as well as a recording. And we do have HRCI credit available today for human resources professionals who are participating. If you're an HR professional and you'd like to receive credit for today's webinar, please download the credit form from the Work-Life Law registration page, same one that we were just referencing. And to get the credit, listen for the 3 codes that I'll read throughout the webinar and write them down on the credit form, and then please complete the rest of the form and return it to Work-Life Law as indicated on the form and on the screen. So let's start with the first code for people who are who want the credit. The first code is C07T. That's C as in Charlie, the number 0, the number 7, T as in Tom, C07T. So we have a lot to cover today, so let's go ahead and just jump right in. I'd like to start out by introducing you to Gina. She's pregnant with her first child, and she's having some problems with swelling, which has caused carpal tunnel syndrome for her. So her hands and her arms hurt, and sometimes they feel numb. So she asked her supervisor if she could switch around her tasks so she wouldn't keep doing the same repetitive motions, because that seems to make her carpal tunnel worse. And she also asked if she could take breaks to use ice packs on her wrists and on her hands to reduce the swelling. And the supervisor said no, she needed to do her regular tasks and she could use her regular breaks to use the ice packs. So now let's meet Shauna, and she's also pregnant with her first child, and she's been having migraines frequently. Her workplace is right next to a paint department, and the fumes seem to make the headaches worse. And she's also concerned that the fumes might be bad for her baby. So she asked her employer if she could be transferred to a different location, but the employer said no, there are no openings in the other locations. Next we have Jessica, and she's having very bad morning sickness. It seems to last the entire day. She can't keep any food or water down, and she's already been hospitalized once for dehydration. She doesn't feel like she has the strength to go to work, but she's already used up all of her sick days, and her supervisor told her that under the attendance policy, she'll be fired if she misses more time, so she keeps trying to go to work. And then we have Julia, and Julia is pregnant with her second child. She had very serious complications with her first pregnancy, and this pregnancy is considered high risk. And her job involves moving patients, and her doctor told her not to lift more than 25 pounds. So she asked for lifting assistance, but her request was denied. Her supervisor said that she'd have to go out on FMLA leave if she can't do her job, but she's trying to save her FMLA leave so she can stay home for her new baby as long as possible. So, are these supervisors right? Did they come up with the right answers when they were asked for accommodations? They're trying to do the right thing. They're trying to apply policies evenly to pregnant and non-pregnant employees, and they're trying to make sure that the work gets done in the workplace. Sometimes supervisors refuse to accommodate women in an effort to make them quit. And we're going to talk about that a little bit later on, but that really doesn't seem to be the issue here. And in the past, these supervisors probably would have been acting within the law by denying these accommodations. But in the past few years, things have changed, and now they probably are not acting lawfully. So let's take a quick look at some of these changes. Actually, some of them we're going to look at in depth, but let's take a look at these changes. And the first is the pregnancy accommodation issues under the amended Americans with Disabilities Act. And as you may know, the ADA applies to employers of 15 or more employees, and that means it covers most employers. Smaller companies that don't have 15 employees might be covered under similar state laws. So that's something to be aware of if you are a small company. Don't assume that this doesn't apply to you. Under the ADA, a disability is defined as a physical or mental impairment that substantially limits a major life activity. And disability also includes having a record of such an impairment or being regarded as having such an impairment. And those latter two types of definitions can sometimes be relevant in the pregnancy context, but they aren't usually. When we're talking about accommodation, we're usually talking about someone actually having a disability. So for today's discussion, we're going to be focusing on the definition of disability that is on your screen right now. Now, in 2008, the Americans with Disabilities Act was amended extensively, and those amendments became effective in January of 2009. And the amendments did not change the definition that we just looked at, but what the amendments did is they instructed courts to construe the meaning of the words in the definition more broadly. And this came about because the courts had interpreted words like substantially limits and major life activity so narrowly that very few employees were covered under the old unamended law. And so Congress passed the amendments, and it stated its intention that the ADA should be read broadly to provide protection to as many employees as needed it. And in doing this, what the amendments did is they shifted the focus of the inquiry from whether an employee has a disability to whether the employer has provided a reasonable accommodation to the employee. And so the intent was, and actually what we're seeing in practice is, going forward, we aren't going to have this protracted litigation about whether someone actually has a disability. Rather, we're going to be almost assuming it, not quite, but almost, and then focusing on what happens to the employee in the workplace. So before the amendments were passed, pregnancy conditions were treated very differently from the way that they're treated now. Before the amendments, pregnant women frequently lost their disability claims that they brought in court because the courts found that pregnancy is not a disability. Pregnancy is temporary, and temporary conditions can't be disabilities. And pregnancy complications don't involve major life activities. And there was an additional reason why the courts held against the pregnant women, and that's what Joan Williams has called the normal pregnancy doctrine, and that's like a set of judicial decisions or pronouncements that pregnancy-related conditions are covered by the ADA only rarely, only in extreme cases, only if the woman has really severe complications. And so the first change that the amendments brought about is it expanded the idea of major life activity. In the old unamended statute, there was no list of the major life activities, and the EEOC in its regulations provided a short list, such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. And the Supreme Court construed the words major life activity very narrowly, and they said the activities must be of central importance to daily life. And there was a lot of litigation about whether the activities that were limited by a person's impairment actually were central to daily life. Now, under the amendments, the ADA does have a list of activities that are considered major life activities, and it's non-exhaustive, and it includes caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working. Well, that wasn't comprehensive enough, so the EEOC added sitting, reaching, and interacting with others. And so it's easier to see how many of the activities, if not all of the activities that employees engage in on a regular basis are now going to be considered major life activities. But the amendments went further and said major life activity also includes major bodily functions. So this is brand new, something that wasn't in the old law at all. And this is also very key for pregnant women because major bodily functions are so involved in pregnancy. And so now, according to the statute, major life activity includes the major bodily functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. The EEOC added to that special sense organs, skin, genitourinary, oh boy, this is really testing my ability to speak, cardiovascular, hemic, lymphatic, and musculoskeletal functions. Again, very comprehensive. It's easy to see how this is going to apply to pregnant women. So now, common activities that pregnant women engage in or conditions that they experience frequently are likely to come within those lists of major life activities. And here's an example on the screen of how severe morning sickness could involve major life activities. It certainly involves the major life activity of eating. Arguably also it would involve the major life activities of standing, concentrating, thinking, and working. And if we're going to look at the list of major bodily functions, it would also include the digestive system. One thing that's important to know is the employee needs to point to only one of these. I've given several examples just to show how if one is not availing, another might be, but it's important to know that the employee needs to show just one. So the second change that's very important to our discussion today that came about with the amendments is the change in how the phrase substantially limits is interpreted. What the amendments did is they significantly weakened how the courts had been interpreting the phrase substantially limits. The courts had created a really high hurdle for determining whether an employee had a substantial limitation, and there was a lot of litigation on this as well, looking at the degrees of limitation and whether someone was severely impacted by their impairment or if it was just a nuisance or something that was going to be temporary. And so what the amendment did is it wiped all of that away by saying that substantially limits shall not be construed to create a demanding standard or to require an impairment severely restrict an employee from doing activities. So all that an employee needs to show at this point is that he or she is limited in an activity as compared to most people in the general population. Now, so, this is an area where I imagine there is going to be some litigation down the road, and I think we're going to see some refinement of this and some standards adopted, but at this point, that's the standard that we have in the statute and in the regulations. And so when we apply this in the pregnancy context, we can do that by looking at an example. We can see how it has loosened up the standard. If you have a pregnant employee who can't stand for 8 hours because her feet are very swollen, it causes pain and it causes numbness, in the old days, before the amendment, we would say that she was not substantially limited in a major life activity. And that's because, you can't stand. I mean, that's not anything that's, permanent or severe, and it's not going to go on for a very long time. But now what would happen is a court would compare her ability or inability to stand to that of the general population and would say, standing is a major life activity. She can't can't do it as well as the general population can do it, and therefore she meets the definition of a disability. Now, the third change that the amendments brought about that are important for our conversation today is duration. It used to be that courts said that pregnancy-related conditions couldn't be disabilities because they were temporary. And what the amendments did is they did away with the duration limits except for claims that are brought under the regarded as prong. And that's something I had mentioned earlier when we were talking about definitions. Generally, pregnant women don't bring regarded as claims because there's no right to accommodation. If your claim is that your employer discriminated against you because he or she regarded you as being disabled. So since the amendments, regarded as claims can't be brought if the impairment is both transitory and minor. But if the claim is a failure to accommodate claim, then there's no limitation that excludes impairments that are transitory and minor. So duration can still be a factor for the courts to consider in determining whether an employee has a disability, but duration is not a bar that it used to be. And the fourth and final change that we're going to look at today is the elimination of the normal pregnancy doctrine. One thing that's important to remember is that a normal, healthy, uncomplicated pregnancy is not a disability. It wasn't a disability before the amendments. It's not a disability now after the amendments. But just because a condition is pregnancy-related doesn't mean that it can't be a disability. And that's consistent with the purpose of the amendments that we talked about before, the broadening of the scope of coverage, and also the EEOC guidance expressly recognizes that pregnancy-related impairments can be disabilities. And several courts have decided cases since the amendments came out finding that pregnancy-related conditions are disabilities in those particular cases. And so just to wrap this up, we can see how this applies by using an example. Let's assume that we have a pregnant employee who has high blood pressure and she's at the end of her pregnancy. She needs to go on bed rest for a few weeks before she delivers her baby. Before the amendments, a court would have said she didn't have a disability because the high blood pressure would last only a few weeks until she delivered, so that was the duration element, and also because high blood pressure isn't very rare in pregnancy. That's the normal pregnancy doctrine. Now, after the amendments, the courts would likely find that she does indeed have a disability because duration is not a bar, and also because it doesn't matter that the condition is related to pregnancy, and it doesn't matter even that it's common in pregnancy. So let's go back to Gina, Shauna, Jessica, and Julia and look at whether they have disabilities under the ADA now that that statute has been amended. And so with Gina, we know that carpal tunnel is a physical impairment. We know it affects the major life activity of performing manual tasks. And then there are other things that she could argue. If she didn't feel like arguing that, she could say that it affects her in lifting and reaching. She could say it affects her cardiovascular system or her musculoskeletal system. And she would also argue that she's limited compared to most people who don't have carpal tunnel syndrome. She can't use her hands as well. Perhaps she experiences more pain. And so yes, chances are under the amendment she would be found to have a disability. Shauna has migraines, if you remember, and she probably would argue that that affects her ability to concentrate. And it probably also affects many other major life activities, right, because it may prevent her from sleeping. It may make her feel nauseated and prevent her from eating. It could prevent her from interacting with others. It might affect her ability to learn. And she would certainly argue that she's limited compared to other people in those respects. And I think most people would recognize that migraines indeed are limiting to the people who have them. Yes, I'm a sufferer, you can tell. And so chances are a court would find, if asked, that she has a disability. And remember that she also asked for a transfer because she was concerned about the health of her baby because of the fumes. That is not a disability. And we're going to talk later on about whether she has any right to a transfer based on that concern. But for our purposes now, just with the definition of disability, that part does not meet the definition. Jessica, she's the one with the severe morning sickness. That affects her major life activity of eating. And again, there are probably many other major life activities that are affected, and her major bodily functions of digestion. Here with morning sickness, the thing we have to look at is how severe is it. If she has morning sickness for a few days, and each day it lasts a few hours, chances are she's going to be found not to have a disability. And there are many ways that she can get an accommodation for this. You know, she probably has some sick leave built up. She can just take some sick leave. She probably could take some time off under the FMLA. We're going to talk about that later on. But in terms of her having a disability that has to be accommodated by the employer, chances are no. But in Jessica's situation, it really is severe. As you might recall, she's already been hospitalized once for dehydration, and this is going on all day for her, and many days it's been going on. And certainly under the facts as we've presented them here, she would be found to have a disability. So it's an issue of degree, as we'll talk about later on in terms of preventing lawsuits and erring on the side of caution. It's probably better to accommodate her rather than not to accommodate her, but in terms of what the law requires, it's just a matter of looking at degree. And then Julia, with a high-risk pregnancy, she probably also has a disability under the amended standard, because a high-risk pregnancy affects the reproductive system, and a healthy reproductive system is not high risk, so she is limited as compared to the rest of the population that has normal pregnancies, and so she probably needs to be accommodated as well. So let's talk then about what this duty to accommodate is. You know, what does it mean? So, you know, so what? Somebody has a disability. Once you have an inkling, you as an employer have an inkling that someone has a disability, you need to engage in an informal, interactive process to determine if they need an accommodation, and if so, what accommodation they need. And employers are required to provide reasonable accommodation to employees with disabilities unless it would create an undue hardship to do so. And we will talk about what constitutes an undue hardship in a few moments. If an employer doesn't accommodate, then an employee has a claim for failure to accommodate. That's considered a disability discrimination claim under the ADA. So the employer's duty to provide the reasonable accommodation can be triggered in one of two ways. One is the employee makes a request for a reasonable accommodation, but they don't actually have to use those words. They don't have to use any special words. They may say something like, I need help with this, or they might say they're having trouble doing something. Let's see, I think it might have been in Gina's case, I can't remember which one it was now, sorry, but one of them told her supervisor that she was having some difficulty, I think it was getting to work. And so that's enough to trigger your obligations to engage in the interactive process under the statute. The second way that it's triggered is if the need for an accommodation is obvious. And so perhaps you have an employee who has to be completely out of work, or when she's in work, and when she's at work, she's in just so much distress. It's clear that she needs some sort of an accommodation to help her out. And so in that instance, the procedure would be triggered as well. And oftentimes, an employee does not provide enough information for an employer to know if they actually have a disability. So employers can ask for additional medical information, but the request for the information has to be limited to establishing whether the employee has a disability and whether the employee needs an accommodation and what appropriate accommodation can be provided. And so, for example, if a pregnant employee gives her employer a doctor's note saying that she has gestational diabetes, that's sufficient for the employer to know she has a disability, and the employer should ask if she needs any adjustments to her work or to her schedule in light of her diabetes. If she didn't have a note that provided enough information for that, then the employer could ask for additional information, and perhaps the information that the employer would need from the doctor would be things like how frequently does she need to take breaks to test her blood sugar, how frequently does she need to eat, things of that sort, so that an appropriate accommodation can be fashioned. The types of information that the employer is supposed to get is the nature, the severity, and the duration of the impairment, and also the extent to which it limits the employee's ability to perform an activity. So the employer can also ask information about the accommodation, such as the employer can send over to the doctor a description of the employee's essential functions and say, can the employee do this? What does the employee need to be able to do this? And then that information will inform the interactive process between the employer and the employee. There's a really great resource for employers, and I put a link to it here at the bottom of the slide, and that's Ask Jan, which is the Job Accommodation Network. They work with the Department of Labor. They have a sample medical information form online, and I really recommend that you take a look at that because that gives you a very good idea of what you can and cannot ask for. So I've mentioned this interactive process. Let's just talk about that in a little bit more detail. It's an informal process, and what's contemplated is a back and forth between the employer and the employee to get information about the condition, about the limitations, and about what the employee needs. And there might be several proposals that come out of this back and forth from both sides as to what would be reasonable accommodations, and then some further discussions about why something is or is not reasonable, perhaps some tweaks. And the idea is that both sides are supposed to talk through the effectiveness and the reasonableness of each one of these alternatives. And it's important to know that if the employer feels it doesn't have enough information to decide about a reasonable accommodation, that's not a reason for not providing it. The employer has the obligation to go and get some additional information. Also, an employer can't fire an employee or put her on medical leave to avoid the obligation to engage in the interactive process, and that probably sounds very obvious to all of you on the phone, but there are some cases and some situations that are about to become cases in which employees are claiming that they went to their employer and said, I have this condition and I need some help at work, and the employer just fired them. The employer just said, look, if you have that condition, you can't perform the essential functions of your job, and so you're terminated. And sometimes with pregnant women, what happens is the employer says, you can't perform the essential functions of your job, so you are placed on FMLA leave starting now. Well, what happens when that FMLA leave runs out and the employee still is pregnant and still has the condition and still can't do her job? Many employers are firing the employees at that point. That's not a good idea. We're going to talk about that in more detail later on, but I just wanted to give you an example where it's maybe not quite so obvious about firing someone as opposed to engaging in the interactive process. So what makes a reasonable accommodation? A reasonable accommodation is a change of how and when and where an employee works. And the idea is it's supposed to enable the employee to perform the essential functions of her job. It's important to know that employers are not required to remove or to change essential functions of the job. They might be required to remove or change marginal functions, but not the essential functions. So here's an example of how that might play out. If an employee's job is to teach third grade, she probably has a long list of essential functions, but let's just for our purposes assume that the essential functions are something along the lines of preparing lesson plans, providing instructions to students, managing student behavior, monitoring student progress, and evaluating student performance. But part of her job might also be to supervise recess and, let's say, to participate in committee meetings in the evenings. So if she has a pregnancy-related condition that makes her really fatigued, a reasonable accommodation might be to remove the marginal activities of supervising recess and participating in the committee meetings so she can save her energy so that she can do her essential functions. And one thing that's also important to know is if there are several different accommodations that might make it possible for the employee to do her essential functions, then the employer, not the employee, gets to choose which one of the accommodations will be used. The employee has a right to a reasonable accommodation, but that doesn't mean that it has to be the accommodation that the employee prefers. Now, one thing to note also is although an employer is not required to remove or to change essential functions, it can do so if it wishes. And in practice, we actually do see this a lot. Many employers do actually change an employee's essential functions of their job just on a temporary basis, just until the employee can do her job again. And related to that, once the need for the accommodation is over, the employee is supposed to be returned to her original position. And I've been talking a lot about essential functions. We don't have time to go into that very deeply today. If you do have any questions about that, you should feel free to contact me. I'm going to give you my contact information at the end of this webinar, and you can find it all over the web. But one thing that's helpful is to have a written job description for each employee that states what the essential functions of the job are. And there are some questions about things such as attendance. Can attendance or regular attendance be an essential function of a job? If you come up with that situation, it's a good idea to talk to your legal counsel about it. The law is quite different from jurisdiction to jurisdiction, and it's a very fact-specific inquiry, so it's a good idea to get counsel involved at that point. So let's look at the different types of reasonable accommodations that are commonly used in pregnancy cases. Things such as bathroom breaks and breaks to either to take a rest or to get some water, an accessible work site, a chair to sit on, modification of equipment. Maybe that just means moving moving a chair up or down so that things are at the right height, or adjusting a shelf or a desk, modifying testing or training materials, changing policies. It could be an attendance policy, it could be a call-in policy, giving people time off for medical appointments, and job restructuring along the lines of what we were just talking about, removing the marginal functions. All of those are reasonable accommodations that frequently come up. Then there are other types of reasonable accommodations that frequently come up that just require a little bit more conversation. One is lifting restrictions. This is an accommodation that is very frequently requested, and sometimes the lifting restriction actually is not related to a disability. If you have a pregnant employee, you have probably come across a situation where a doctor just sends in a note, just a routine note, saying Mary is 12 weeks pregnant. I recommend that she not lift more than 25 pounds. And there's nothing wrong with Mary. It's a totally normal, healthy pregnancy, at least at this point. And so a question comes up about whether that lifting restriction should be honored or not. And as we'll talk about a little bit later, generally speaking, it's a good thing to do, but it's not something that the law requires. But if Mary does have a disability, perhaps she's got a bad back, could be related to pregnancy, could not be. Perhaps she's got a high-risk pregnancy and her doctor doesn't want her to have any strain on her abdomen from lifting. Those types of situations may constitute a disability, and so there may be an obligation to provide lifting restrictions. One thing that can be done in a situation is looking for creative solutions. For example, an employee's job may not really be to lift, but it may be to transport boxes from point A to point B. So then we think about different ways that you can transport those boxes, and it might involve using a cart. It might involve using a dolly. And there might be other solutions also for lifting restrictions. It might involve getting coworkers to step in and to help with lifting. There's one case on the books in which an employer allowed a man and a couple, I think it was a man and a woman, to have help with lifting. One of them had a bad back, one of them was getting along in age. A woman got pregnant and asked to have a similar assistance with lifting. It just, it didn't happen very frequently, but every now and again, heavy box, she just wanted somebody to step in and help her. And they said no, even though they had been doing it for the other two employees. So it's important to also keep in mind that if assistance is provided for other employees, it should be provided for the pregnant employees as well. And the reason why I spend so much time on lifting restrictions is it really is one of the most frequently requested accommodations, and it's the one that gets employers into difficulty the most often, because employers frequently say, no, your job is to lift, and so we need you to lift, and if you can't do it, you have to go out on leave. And then, of course, they terminate them one way or the other, and that's why we see so many lawsuits in this area. So if there's a way to accommodate it, it probably is a good defensive move on the part of the employer. Okay, the next one, schedule changes. We find that creative use of scheduling can be very effective when dealing with things like morning sickness and fatigue. You can keep an employee working longer if you can allow her to come in later, for example, if she has morning sickness that just lasts for a couple of hours in the morning, or if you can give her, say, a half-hour break, 45-minute break in the afternoon so she can take a nap. And it doesn't have to be a paid break. You can make whatever compensation adjustments you need to make to reflect this, but it's a reasonable accommodation. It probably wouldn't burden the employer too much. Light duty is another very big issue, gets employers into hot water. The law says you don't have to create a position, a light duty position, for an employee who needs a reasonable accommodation. Many employers do, but it certainly doesn't have to be done. And as we will discuss in a little bit, some employers have a policy where they will provide light duty to certain groups of employees, such as those on workers' comp, those who are injured on the job, and now that probably is not going to fly any longer. So we'll talk about that in more detail. Another type of reasonable accommodation is transfer or reassignment. And the guidance says, the EEOC guidance says that this can be reasonable if there's no other accommodation that would allow the employee to do her job. So if it's possible to leave an employee in her current position with some accommodation, some lifting help or some breaks, that would be preferable to transferring her particularly to a different location, which can create a lot of issues as to whether the transfer is punitive and things of that sort. Also, the employee, you don't have to create a position for the employee. It's enough if you have a vacant position. If you don't have a vacant position, you're under no obligation to create it. You don't have to move an employee who's in a position to a different one to create a vacancy. And transfer is reasonable only if the employee has the skills she needs to do the job. And then a couple more to talk about. Work from home is an interesting reasonable accommodation. Pregnant women ask for this a fair amount, and it used to be sort of up in the air. I guess it actually really still is up in the air as to whether it's required. The EEOC guidance seems to suggest that employers should provide at-home work if it's something that's feasible. There was a case that was just decided in the Sixth Circuit in which the Sixth Circuit initially said that working from home is a reasonable accommodation. It was not a pregnancy case. It was a different type of case. And then the Sixth Circuit reheard the case, and the en banc opinion said that it was not a reasonable accommodation. But if you go and you read the opinion, it's a very fact-specific opinion. And so it doesn't give a lot of comfort to either side. It really doesn't provide a final answer for either employers or employees. And so it's important to engage in a fact-specific inquiry before you decide whether it's a reasonable accommodation in your workplace. And the sorts of things you would be looking at would be the nature of the employee's job and whether she can do it at home. You know, obviously if she has to interact face-to-face with customers, that's not something that she can do at home. Also look and see who else in the organization is allowed to work from home and see if there's a meaningful difference between them. Those were two issues that came up in that case. It's something that a lot of employers do allow their employees to do because it keeps the employee productive. The employer is still getting some work out of the employee. And then leave is another very sticky area of reasonable accommodation. Certainly you cannot force employees to take leave. That used to always happen in the past. Someone would come to their employer and say, I'm pregnant, and the employer would say, okay, you're on leave now. That is not consistent with the law, particularly the Pregnancy Discrimination Act, as we'll discuss in a little bit. It's reasonable to put an employee out on leave only if there's no other accommodation. And the reason why it's not preferable is usually leave is unpaid, which can work a real economic hardship on the employee at the same time that she needs to have a salary to prepare for her baby. She needs to have health insurance. And so it's really not favored. It also can lead to termination, as we talked about. But if she does need to be out on leave, that does not have to be paid leave. After she's used up all of her accumulated sick time and vacation time, the rest of the time can be unpaid. And the courts have been pretty clear in saying that very long periods of leave are not reasonable, and open-ended leave, where a doctor isn't able to say after such and such period of time I expect that my patient will be able to return to work, open-ended leave is also not reasonable. And this will come up oftentimes after the pregnant employee has had her baby, because if it's a condition related to pregnancy, you pretty much know when that's going to end, if it's a condition that will end upon delivery. But let's say that the employee has a disability that arises during delivery, or she has something that started during pregnancy but can continue past delivery, she may get to the end of her maternity leave and not be able to return to work. If there's no idea when she's going to be able to return, or if she's not going to be able to return for a year, then leave is most likely not a reasonable accommodation, and the employer is not required to provide it. It's typically a situation where a doctor can say, I expect that her situation will be resolved in the next 3 to 4 weeks. Those sorts of situations where the court says it is reasonable to provide leave and the employer is required. So I mentioned earlier undue hardship, and an employer is not required to provide a reasonable accommodation if it would create an undue hardship for the employer. And the statute defines this as an action requiring significant difficulty or expense. And the things to be considered are the nature and the cost of the accommodation, the financial resources of the employer, the number of employees that the employer has, the types of facilities the employer has, the employer's operations, and the EEOC has added a fifth one, impact on other employees. So the burden is on the employer to prove that something would create an undue hardship for them, and it's not supposed to be based on conjecture. An employer is supposed to provide evidence of a cost-benefit analysis and some hard numbers to prove its case. We haven't seen a tremendous amount of litigation on this. I don't really expect we're going to, because it's not something that employers commonly bring up. Usually the accommodations that are requested are fairly minor compared to the resources that the employer has. So let's go back to Gina and everyone and look at whether what they requested was a reasonable accommodation or not. Gina wants to take breaks from her repetitive tasks, and she wants to be able to have time to put ice on her wrists. Both of those are probably reasonable. There are two alternatives there. So the employer can choose one or the other. The employer could start by offering one and see if that takes care of the situation. If not, then combine it with the second one. And if she does take breaks, as we discussed, the breaks can be unpaid. Shauna wanted the transfer, and that's not required under the law because, as her employer said, there are no vacant positions to transfer her to. But if the employer has created positions for non-pregnant employees who are in similar situations where they want to get away from the fumes, the employer really should do it for her as well. And we're going to talk in a moment, some state laws require transfers, and so in that instance, a transfer may be the best thing for the employer to provide. There might be some alternatives. The employer might want to get creative. There might be some other ways to get her away from the fumes, and one of those might be offering her the opportunity to work from home. Jessica, as you might remember, said to her supervisor she felt too weak to work, and so that has to be taken as a request for accommodation, and that starts the interactive process. Allowing her to miss work, which is essentially placing her on leave, might be a reasonable accommodation, but the employer first probably wants to see if there's another accommodation that will help her to do her job. So it may be making a schedule change. It might be letting her take naps during the day. Also, she might be eligible for FMLA leave, and we'll talk about that in a moment. Julia is the one who asked for the lifting assistance, and the supervisor should go through the various alternatives with her, see if there's something that will help. A lot of nursing facilities have assistive devices. I'm not sure if I spelled that correctly, but in any event, and they allow or actually require teams of people to lift patients. They also often have light duty. So if the employer has any of those alternatives available to it, then that would be something to discuss with Julia. Forcing her out on FMLA leave really is risky, and it's not something that I would necessarily suggest. So let's leave the ADA for now and start talking about state and local laws, because this is another area where there have been a lot of changes in recent years. We're starting to see a lot more laws, and it is starting to impact a lot more employers. Here's a list of the states that currently have pregnancy accommodation laws. Those are Alaska, California, Connecticut, Delaware, Illinois, Louisiana, Maryland, Minnesota, New Jersey, Texas, and Virginia. And my understanding is that New York is getting close to passing a pregnancy accommodation bill. It may have actually done it in the last day or so. You may have heard that there's a national bill, the Pregnant Workers Fairness Act, that's been hanging around for the last few years. It remains stalled. It's unlikely to go anywhere, so that makes these state laws more important. One of the things to note about this is that if an employee is in a state that requires accommodation, chances are that state law is going to be stronger than the ADA. It probably applies to more employers. It might require accommodation even if the employee doesn't have a disability. It probably doesn't have a cap on damages. So those are all important things, particularly for the lawyers on the phone, to be aware of. I've given you links in the handouts to more information about these laws. There are links that, there are resources on there that have links that go state by state and tell you what's required in your particular states where you operate. And the laws in each one of these states are different, but in each one, employers can't refuse to provide medically necessary accommodations to pregnant women unless it would create an undue hardship. And then some of the states do go further, and they say that employers have to provide accommodations even if it's not medically necessary, if it would be safer for the woman or safer for her unborn baby. Some also say that if employers transfer other non-pregnant employees, they also have to transfer pregnant employees if the pregnant employees request it. So no involuntary transfers. And they have to move them to a safer or less strenuous position in those situations. So it's not moving them to a high-risk situation, but a safer or less strenuous position. And then once the pregnant employee is better or has returned from maternity leave, these statutes require that she's supposed to get her original job back or an equivalent job. And all of the laws prohibit forcing a pregnant woman out on medical leave if she doesn't want to take leave, and if there's an accommodation possible that will allow her to continue to work. So, why don't we just take one of these and look at it as an example. California requires reasonable accommodation for an employee who has a condition that's related to pregnancy, childbirth, or related medical condition. And when the employee requests it, and with the advice of her health care provider. So, we have several steps there, that boxes that need to be checked off before the obligation to accommodate comes into being. And then in addition, if the employer has a practice or policy of transferring temporarily disabled employees to less strenuous or hazardous jobs, they have to similarly transfer the pregnant employee if she requests. And even if the employer doesn't have such a practice or a policy, if the pregnant woman requests the transfer with the advice of her physician, a temporary transfer, say, to a less strenuous or hazardous position for the duration of her pregnancy, if the employer can reasonably do that, it can't refuse. So that is a much stronger transfer provision than we see in other statutes. And then in late 2012, California adopted some regulations that provide further details about the employer's obligation to provide reasonable accommodations. And now reasonable accommodations include any change in the work environment or the way a job is done that allows a pregnant employee to perform the essential functions of her job. And examples are changing work practices, policies, or duties, modifying work schedules to permit earlier or later hours or more frequent breaks, such as may be necessary to use the restroom, and providing furniture such as stools or chairs, or modifying equipment. Now, in addition to state laws, we also have some cities that have passed pregnancy accommodation laws: New York, Philadelphia, Providence, and D.C. And let's just look quickly at the example from Philadelphia. Philadelphia's law is pretty broad, and it says that employers have to provide reasonable accommodation for pregnant workers who need them unless it would cause an undue hardship. That part's not broad. We've seen that before. But it doesn't require that the accommodations be medically necessary, and it doesn't require a doctor's certification. So if a pregnant woman needs, for example, more restroom breaks, she can get them in Philadelphia even if she doesn't have a doctor's note, as long as it doesn't provide a problem for the employer. So let's switch our focus now and look at accommodation under the Pregnancy Discrimination Act. It also applies to employers of 15 or more, and it requires employers to treat pregnant employees the same as other employees who are similar in their ability or their inability to work. So, for example, if an employer provides lifting assistance to a male employee with a bad back, it should provide lifting assistance to a pregnant employee who has a bad back because of pregnancy. And as we've mentioned, you can treat pregnant employees better than others. You just can't treat them worse. I sometimes get calls from employers who say they want to offer an accommodation or extended leave to a pregnant employee, but they can't because they don't offer it to non-pregnant employees. And the answer is simple. They don't have to worry. The Supreme Court decided several decades ago that the PDA is a floor, not a ceiling, and employers are free to be more generous in how they treat pregnant employees. As you probably have heard, the Supreme Court recently decided a pregnancy accommodation case, and this was Young versus UPS. It involved a pregnant UPS driver who had lifting restrictions, and at the time, UPS provided light duty to employees who were injured on the job or who had their licenses suspended or they had disabilities, but it didn't provide light duty to pregnant employees. And notably, it has since changed its policy. It now does provide light duty to pregnant employees as well. So Young sued for discrimination, and it's important to know that this case came up before the amendments to the ADA, so there was no issue about whether she had a disability that needed to be accommodated. And the trial court granted summary judgment to UPS, and the case was appealed, and the Supreme Court reinstated her lawsuit. And what the Supreme Court said was that if you have a policy, if the employer has a policy of accommodating certain types of employees but not pregnant employees, a plaintiff can get trial, a plaintiff can survive summary judgment if she can show that that policy places a heavy burden on pregnant employees, and it really wouldn't burden the employer to provide the accommodation to the pregnant employees. And the employer is not allowed to argue that expense or convenience are burdens. So that means it's very hard for an employer to come up with a showing that will be acceptable in this situation. It will be very hard for an employer to justify having a workplace policy that allows light duty for some groups of employees but not pregnant employees. And as a result, most employment lawyers are advising their clients not to limit light duty to employees who are injured on the job, but to open it up to pregnant employees as well. Now, we've mentioned the FMLA a couple of times today, so let's talk about that. The FMLA allows pregnant women to take time off for prenatal visits and pregnancy-related conditions, including morning sickness. Of course, they have to be eligible for the leave, so that means they have to work for an employer who has at least 50 employees within a 75-mile radius of the work site where the employee works. The employee has to have worked for the employer for 12 months, although those don't have to be consecutive months, and the employee has to have worked at least 1,250 hours in the prior year. The FMLA gives employees up to 12 weeks of protected leave per year. And so if women take off time for prenatal visits or pregnancy-related conditions, they may be using up some of the time that they otherwise would take for maternity leave. And I use the word may because the FMLA allows employers to choose different ways to measure that year. And it might be a calendar year, it could be a rolling year where you look at the 12 months preceding the start of the leave. There are a couple other ways to do it as well. And the employer needs to choose a method for all employees and notify them about it, or the employee can choose the method that's most advantageous for her. Now, the FMLA is protected leave, meaning that the employees can't be fired or discriminated against for requesting or taking leave, and they have to be restored to their same position or a substantially similar position at the end of their leave. And FMLA leave can be taken in a continuous block, or on a reduced schedule, or intermittently as needed. We'll talk about the one exception to that. Employees are supposed to give 30 days notice of their need for leave, and of course, in the case of maternity leave, that's very easy because everyone has a rough idea of the due date, but in the case of pregnancy-related conditions, it might not be so easy. In that instance, the employees are supposed to give notice as soon as they can. And employers can request medical information to substantiate the employee's need for leave if they want to. They're not required to ask for medical information. But in the case of pregnancy, one thing to keep in mind is that the requests of pregnant employees need to be the same as the requests of non-pregnant employees. So for example, if a pregnant woman announces that she's pregnant, the employer should not reflexively say, okay, I need a doctor's note clearing you to work, because the employer doesn't require all of the other employees who aren't pregnant to provide notes saying that they can work. So the Pregnancy Discrimination Act comes into play in that situation. Similarly, employers shouldn't ask for a doctor's note clearing an employee to work after maternity leave unless they ask for a doctor's note from all employees who are returning from leave. There we go. And employers, we find, often fail to advise their employees about their rights to take leave. Sometimes they discourage them from taking leave, and so that can give rise to lawsuits. And there are two more quick things about the FMLA before we leave, because I know that we are running short on time here. One is that you need to look at your state's laws about leave, medical leave and family leave, because some states allow piggybacking, where a pregnant woman can take some leave under one statute for her own medical condition and additional leave under the other statute to bond with her baby. So in DC and California, pregnant women can do that. And in California, that means that some employees can take up to 28 weeks off for pregnancy and child bonding, depending upon their condition. And then also, as we alluded to before, if an employee can't return to work at the end of her maternity leave because of an impairment, the ADA may require that the employer provide some additional leave as a reasonable accommodation. So let's take a break again, excuse me, for an HRCI code. The code is, and actually it's WR07C. And let me see. So it's W as in William, R as in Robert, the number 0, the number 7, and C as in Charlie, WR07C. So let's change now and look at the best practices for managing pregnant employees and for avoiding lawsuits. Companies spend a lot of time, a lot of effort and money recruiting and training employees, and so it makes sense to invest in retaining them. And when you're talking about whether you should accommodate pregnant women beyond what's required by the law, it's important to get this big picture, look at this investment that's been made, and make decisions going forward that are consistent with the idea of retaining employees. As many studies have shown, it's cheaper to retain good employees than it is to have to constantly replace them. And retention can keep your workforce productive because you don't have lag time while vacancies are filled and new employees are trained and they get up to speed. And importantly, it allows you to retain good employees, and those employees continue their relationships with customers and with clients, and that stability improves customer service and satisfaction. And increasingly, increasing retention means that your workforce is not distracted by the drama of the comings and goings and wondering, is everybody else leaving? Should I be looking for a new job too? And so this stability helps everyone to have better relationships and feel more connected to their workplace. And so for all of those reasons, it's good to retain pregnant employees if it's possible. Many employers do it. They feel it's the right thing, it's the moral thing to do, but it also makes economic sense. And these employers know that providing some extra breaks or letting someone work a different schedule or take a nap, it's going to keep them working and keep them being productive. And in addition, it shows the employees the kind of care that the employer has for the employee. It makes them feel more loyal. It increases the likelihood that they'll return to work after maternity leave. And of course, it can reduce the chances of being sued. So sometimes when I talk about this, I have people in the audience say, but what about the slackers? How should we handle those lazy pregnant employees who just try to get out of work? And quite honestly, they usually don't like my answers. My first answer is usually to ask them, why did they have lazy people working for them in the first place? That has nothing to do with pregnancy. If you have lazy pregnant employees, chances are they were lazy before they became pregnant. And so the first part of the answer is just to help your managers manage better. They need to hire the right people and communicate expectations and goals and hold the employees accountable for meeting them. And they need to provide accurate and honest evaluations that can weed out the underperformers. And the second part of my answer usually is to ask them if their pregnant employees are actually lazy. And this means reflecting on their perception that the employees are acting in a lazy manner. As you probably have been reading about in the media, we all have biases. We all have unconscious biases, and this affects how we perceive the actions of the people around us, even though we're usually not aware that these biases are affecting our perceptions. One thing we know from social psychologists that's very important is that we notice and remember things that are consistent with our biases. So if a supervisor believes that pregnant employees are going to be absent a lot, that supervisor is likely to notice and remember when a pregnant woman is home sick for a day. But if you have a non-pregnant man who stays home for a day, same amount of time, to take care of a remodeling project, the supervisor will probably not notice it. And if he or she does notice it, will probably forget it right away. And so part of my answer to these people is test your perception of laziness. Articulate what the specific behaviors are that you're seeing that you think are lazy. And that's a good way to stop the biases. When you stop dealing with your gut and dealing with your perception and looking at the hard data, that's a good way to stop the influence of biases. And then also look and see if other employees are doing the same thing and you're just ignoring it. You know, Paul appears to be tired and working at half speed, and you know it's because he's building a deck on his house in the evening, so you cut him some slack. You know, Patrice is tired and appears to be working at half speed, and you assume it's because she's pregnant and you're ticked off by her laziness. Well, that tells you, if you're treating these people differently, perceiving things differently, that tells you that bias is probably a factor. And we know that bias doesn't just affect whether we give somebody a second chance, but also whether we give them good assignments, whether we give them stretch opportunities. It affects their status within the organization and their relationships and their mentoring. Of course, it affects their evaluations. If we notice and remember the negative things and we don't notice and remember some of the positive things, that's going to impact the evaluations. Evaluations, of course, impact compensation, particularly discretionary bonus-type compensation, and all of this feeds into whether a person is going to get a promotion. So the common things that we see in pregnancy bias are assumptions that pregnant women are not as competent as others, they're not as committed to their job, they're not as dependable, and they're just going to quit once they have their babies. All of that sounds pretty negative, and it's important to know there also can be benevolent stereotyping or benevolent bias, such as the employer who decides not to give a pregnant employee a stretch assignment or an opportunity to travel and make a particular presentation because the employer is trying to do the right thing by this employee and not make her too tired or stress her out too much. The problem with that is you often need to have those kinds of assignments and experiences in order to grow in your job and to progress and to be promoted. And so what it does is it creates a mommy track. And when I say this, when I'm giving presentations to companies, oftentimes folks will just throw up their hand and say, I give up. What am I supposed to do? I'm damned if I do and I'm damned if I don't. And the answer is don't assume. Ask. Go to the pregnant woman and say, I've got this trip that involves, going to Thailand for 3 weeks. Do you want to do it? And that way, you're not making any assumptions. Bias is not in play. And when you do make personnel decisions based on these biases, it can lead to family responsibilities discrimination, which is employment discrimination because of family caregiving obligations. And it affects mothers and fathers of young children, that's obvious, but also pregnant women and caregivers for family members such as sick spouses and partners and aging parents and children who have disabilities. The EEOC calls this caregiver discrimination. And we don't have time to go into this in any great depth, but I've given you a lot of resources in your handouts that will explain FRD to you. But let's talk a little bit, just briefly, about what you can do to prevent this. The first is understanding how FRD manifests in the workplace. It can be things such as firing workers when they say that they're pregnant, demoting pregnant workers to an easier job, putting them on medical leave, not promoting them, making their jobs harder, hoping that they will quit. All of these are real-life situations. So here are a few don'ts that will help you prevent FRD. Don't assume that a pregnant employee isn't committed to her job. She's showing up, she's doing her best under trying circumstances. She's probably working harder and showing her commitment more than someone for whom it's really easy to show up at work and get something done. Don't assume that she won't return after her leave. We hear many stories of employers saying, well, Sally won't be back after she gives birth. And it can become a self-fulfilling prophecy because she becomes marginalized and she knows that the assumption is that she's not going to return, and then that can feed into her feeling that it might be better if she didn't. Also, don't make comments about her body, don't make jokes about pregnancy, don't ask her personal questions, don't touch her stomach. We hear many, many horror stories from employees who really are deeply offended and feel harassed by these types of things, which might be well-meaning on the part of the supervisor, but it's important to make sure that they don't do any of that. Of course, it's important to apply rules consistently to pregnant employees and non-pregnant employees. For example, Supervisor Sal watches the clock to make sure pregnant Pam arrives on time, but doesn't track the arrival times for other employees. Or maybe Supervisor Sal writes up pregnant Pam for missing her quota, but gives other employees who missed their quota a second chance. Those are recipes for disaster. You're going to be in the courtroom. So you want to make sure that the rules are not being applied more stringently to the pregnant employees, because you're going to have a plaintiff's lawyer looking at all of this and saying, I wonder if this employer is trying to set Pam up for termination, and you'll see a lawsuit. One of the best ways to prevent FRD in a workplace is to provide training. You want to provide training for HR, obviously, so they understand the situations and they know how to handle it proactively. And it's also very important to provide training for the supervisors, the people of the one-to-one interaction with the caregivers and the pregnant women on a daily basis, because no matter how well-intentioned a company is, no matter how great its policies are, if you don't take care of that relationship between the supervisor and the employee, you can get sued for FRD. There's a long list of companies that made Working Mothers 100 list over the years that have been sued for FRD. And then the sorts of things you want to cover in a training are, what is FRD? Why does it violate the law? How does it violate the law? Why does it arise? What are the assumptions about caregivers? Why should we bother to retain caregivers? What are our company policies? And then what can we do to make sure that bias doesn't affect our own personal decision making? One of the things that I often tell people is you can have this type of a training as part of your existing diversity and inclusion training, or it can also be done as standalone training. HR oversight is so important. You know, now that you have listened to all of this, that when an employee announces her pregnancy, that's a triggering event for FRD in many supervisors' minds. And so you know that once somebody's announced her pregnancy, or perhaps once she's returned from a maternity leave, those are times when FRD is most likely to arise. So you as HR, or as company counsel, want to keep an eye on the supervisor's decisions that are made after that. Interestingly, the research that we've done at the Center for Work-Life Law shows that new supervisors are a triggering event for FRD. And the reason for this is that the new supervisors come into the workplace feeling like they need to clean things up, they need to get rid of dead wood, they need to make sure everything is functioning smoothly. Well, who's the dead wood? Usually, because of their biases, they assume that the dead wood is it's the caregivers, it's the pregnant people, it's the mommies. And so they start doing things to try to get rid of them, either to make them quit or to justify terminating them. And so one of the things that we usually advise HR to do is really keep tabs on those new supervisors and look at why it is that they are doing this. They don't have relationships with these caregivers and these pregnant women. They don't understand their value to the organization. They might not understand the organization's interest in retaining good employees. And so make sure you just keep tabs on these new supervisors, make sure that they are doing what they should be doing. When you are looking for things that these supervisors are doing, look for things like suddenly negative evaluations. That's a real tip-off that bias may be at play, or FRD may be at play. And it's particularly interesting in the case of pregnancy, because you can have someone who has great evaluations, then she becomes pregnant, then she suddenly has negative evaluations. Now, it is possible that her performance actually did fall off. But it's also possible that what changed was the supervisor's perception of her performance or the supervisor's desire to get rid of her. And in this instance, she doesn't need a comparator if she decides to sue you, because she is the comparator for herself, assuming that her performance didn't change. And so one of the things that her lawyers will be looking for are evaluations from third parties outside the company about how she was doing, and looking at quantifiable performance metrics that can't be changed by perception. Look for other things such as goal increases. One thing that we see sometimes is all of a sudden a pregnant woman has her quotas or her goals increased, uneven application of rules or discipline, we already talked about that, and demotion or transfer. One thing that comes up, and we're just about at the end of our time, so I'm going to speak a little bit more quickly, and let me give you the third code before I do that. The third code for HRCI credit is KL91S. That's K as in King, L as in Lincoln, the number 9, the number 1, S as in Sam, KL91S. We've actually talked about accommodation without disability a little bit. Sometimes pregnant employees will ask for an accommodation to prevent injury to themselves or to protect an unborn baby. It's usually not required, except in some states, as we've already talked about. It's probably a good idea to do it. It's going to increase loyalty and engagement, but it also sends a very positive message to other employees. And there's always that question lurking out there whether an employee can sue her employer if she miscarries or has her baby born with birth defects after an accommodation was denied. And let's see, handling long maternity leave. So what I'm going to do at this point is I'm going to talk still for about another 5 minutes. If you need to leave, please feel free to do so. And a recording of this will be on our website sometime early next week, and you can come back and hear what you missed. So a lot of times supervisors are concerned about handling long maternity leaves. And one thing that they need to remember is that a maternity leave is like any other leave that employees take, and almost every employee is going to take an extended leave during his or her career. It might be for their own health, it might be for the health of a family member. The only thing that's different is with maternity leaves, you get advance notice and the opportunity to plan. So how do you handle these long maternity leaves? One idea is to create a coverage plan. This is something that's worthwhile doing for every employee, whether they're pregnant or not, because everybody might be gone at some point during their career. You want to know how everybody's work will be covered if they're out for several weeks, and have a bunch of different alternatives available to you, such as you can hire contractor temp employees. If you have underutilized employees in your organization, you can cross-train them to cover somebody else's job. That's a great thing to do. As you've probably read, employees often love learning new things and having new challenges and new opportunities. You can also take apart their duties, disaggregate their duties, and decide which ones could just be left undone because they're not important, which ones could be outsourced, which ones could be automated, which ones could be done by other people. So in other words, you don't have to take an entire job that one employee was doing and putting it on the shoulders of another. You can split it up and move it around and come up with some alternatives. One thing that's important is don't ask new mothers to work while they're on leave. We see in the case law and we hear complaints from folks that a lot of times mothers are asked to work, quote unquote, while their babies are sleeping. And so that is not a good idea. That is going to lead to an FMLA violation. Another thing to do to help with long maternity leaves is to have a gradual return to work policy. I mentioned before that in the FMLA context, leave can be taken in a continuous block or on reduced leave or on an intermittent basis. Well, when it comes to the time that's taken after giving birth or after adopting, what the FMLA provides is that time must be taken in a continuous block not intermittently, not on reduced leave, unless the employer agrees. And here's a situation where we find a lot of employers agreeing to allow employees to take FMLA on a reduced basis because it gets the employee back into the workplace much sooner. So for example, if they have 12 weeks of leave, what they might do is take 10 weeks of leave and then take 4 weeks of half time. So they're in the office half time, they're at home half time, and that gets them back in sooner than they otherwise would have been. And it also just allows better planning. These people don't have to set up formal flex time or part-time arrangements. It's just something that's assumed, and so their employers, their supervisors, and they can plan better. And I think that this is our last slide. One thing that's important is when you're managing pregnant employees is to prevent backlash from non-pregnant employees. And usually we see this coming about because of poor management. It's usually a workflow issue. Employees who are not pregnant often feel that they get dumped upon when a pregnant employee is out on leave or is feeling sick and can't do as much work. And so it's important to manage the workflow along the lines of what we talked about earlier, but also making sure that all employees feel appreciated and the lines of communication are open for all employees, because sometimes the backlash is simply that an employee thinks a pregnant woman is getting better treatment than he or she is getting, and so you want everyone to feel like they are appreciated and part of the team. And make sure that policies and benefits are available to everyone. Make sure that the people who aren't pregnant understand they too can take leave when they need it. If they want to work flexibly, that's available to them. If you hear a lot of negative talk like, gee, I wish that I were pregnant, I wish that I could leave early, then it's time to step in and talk with the employee who's feeling disgruntled. Maybe that person needs some coaching. Maybe that person needs to better understand collegiality and teamwork. But make sure that they know that that attitude isn't consistent with the goals and the objectives of the company. So thank you very much for your very kind attention today. I've put on the screen my contact information, and you should feel free to get in touch with me if you have any questions, and I hope that you use the resources that are in your handouts. Thank you very much.